According to Section 25 of the Indian Contract Act 1872, an agreement made without consideration is void. Consideration implies that both the contracting parties undertake to give something of value to each other. Is consideration always in monetary terms? Let's explore the following case. In the case discussed, Kedarnath Bhattacharji, a municipal commissioner and trustee of the Howrah Town Hall Fund, had been involved in efforts to construct a town hall in Howrah. After raising sufficient funds, the commissioners entered into a contract with the contractor for the construction. However, as the subscription list grew and the plans expanded, the cost increased beyond the agreed amount. Despite the variation in the contract terms, the commissioners were held liable for the increased cost as they had authorized and approved the changes. The defendants, Gorie Mohammad, had made a subscription towards the construction but later refused to pay. The commissioner sued Gorie Mohammad to recover the amount subscribed. Initially, the lawsuit was filed in the Howrah Court of Small Causes with the power to sue granted by the registrar of the court under Section 30 of the Code of Civil Procedure of 1908. However, the defendant argued that the plaintiff lacked the right to sue, and the Small Cause Court judge agreed, stating that the registrar did not possess the authority to grant leave to sue. The court also classified the town hall as trust property and deemed the plaintiff's suit invalid from the beginning. The court held that the defendant Gorie Mohammad is liable to honor the promise he made in the contract, even if it is not entirely to his benefit. The defendant cannot retract or refuse to fulfill his commitment after the commencement of the contract. The court emphasized that the defendant, as a subscriber, has a responsibility towards a promise he originally made and he cannot evade it. Furthermore, the Calcutta High Court determined that the plaintiff's suit is legally maintainable, indicating that the plaintiff had the right to file the lawsuit to recover the amount owed to them by the defendant. It is clearly evident that the promisor cannot revoke the promise once the promisee commenced the performance or process mentioned in the contract. The Calcutta High Court, in its judgment, without a doubt stated that the promise cannot be revoked after the commencement of the act as per the contract.